Secondly, I'm sure you guys will have some questions that pop up throughout the presentation. If you've got anything to ask Karalynn, just go ahead and keep it to yourself until the end of the presentation, at which point we'll have a Q&A. So you can submit those questions in the chat, or you can unmute yourself and ask Karalynn those questions yourself. But either way, we'll make sure to get any questions that you've got throughout the presentation handled and taken care of at the end of it. So without any further ado, thank you for joining us this morning for the Legal Landmine webinar. Our owner and managing partner, Karalynn, will be walking you guys through some need-to-know information regarding how to better prepare yourself and your business for facing legal landmines. So I'm going to go ahead and pass it over to Karalynn, and we'll get this started.
Hey, good afternoon, guys. I'm glad you all can make it. Today is kind of jumping into things that I call legal landmines. And so let's dive right in. What is a definition of a legal landmine? And could your company survive one? So what I call a legal landmine is things that are out there that you don't even know that you should be aware of, especially if you're new to business or just getting started, or if you're changing directions, doing something a little different, or just want to make sure your business is in the best shape it could be. We're going to go through some of the main ones that I see a lot of my companies I represent in the construction industry really be unaware of until they've already hit a landmine, and then we're doing everything to scramble. And so what I'm trying to do is prevent you from hitting the landmine so that you don't have to scramble to try to cover all your bases. And then, because once you hit it, it's not what can we do to prevent it, it's, you know, what can we do to mitigate the damages, how much is this going to cost, what is our exposure, all of those things, as opposed to we can put in some time on the front end and really mitigate the risk that those things will ever happen. So, I've started some businesses both, in the legal world and in the construction industry, and we've had, instances when we were first starting out that were missteps, right? We once hired a driver that didn't have the proper license and unfortunately didn't realize it until there was an accident. It was a minor accident, but still the insurance covered it. If not, I mean, we were still in the early stages. I don't know if the company would have been here today if we would have had to pay for the damages. So, we didn't have an employee handbook. We had a form that you got at Home Depot, or not Home Depot, Office Depot. It's like an application. We filled it out, did an interview. We were so busy, let's just get started. And that's kind of how it went. And that's how we got in trouble. And so that's what I'm trying to prevent, all of you guys from running into is, obviously when things happen, we learn from them, but can we learn from other people's lessons and not have to learn the same lessons the hard ways like they did or like I did? So that's the first one. Okay, so the legal landmine construction checklist, this is specifically for businesses in the construction industry. First and foremost, for any company, if it's going to be conducting business, you must be incorporated. Now that's an LLC, an Inc. filed with the Secretary of State, and that you have to every year you have to file an updated report to keep that company in good standing. Sometimes you'll have franchise taxes as well. That all depends on what kind of business you have and if you're paying sales tax, and all of that needs to be, make sure that it's taken care of, because if you're not incorporated, or if you don't run your company like an actual company, then it won't provide the protections, right? And so what are those protections? The protections are, if your company can't pay a debt, or if there's some kind of, you get in an accident and there's not insurance coverage, that they couldn't come after your personal assets to satisfy any judgment. So making sure you're incorporated, make sure that stuff stays in good standing. Because if it's defunct, you have a limited amount of time to get it back into good standing for it to be effective. And sometimes I think the gap, if you fail to file your yearly form or whatever, and your entity status is forfeited, there is a gap between the time it's forfeited and reinstated, you could be personally liable for debts incurred in that gap. So make sure you keep everything up to date. All right, another thing that I see a lot, especially in the construction industry, that people like to pay daily rates or things like that, you have to really know the difference between a subcontractor and an employee. Just because we call somebody a subcontractor or we call them an employee doesn't make them so. So we're going to kind of go through what things you need to look at and what are the requirements for that. if you determine and we have that you have employees, they must be paid properly. That means, overtime, keeping time records, even if they're on salary. So that's some other things that we need to dive into. If you have employees, you need a proper intake process, an up-to-date employee handbook, everything that's up to date. So, and that's the first thing. Like if there's an OSHA event or you get sued with an accident with an employee, the first thing that the other side is going to ask for in a lawsuit is your handbook, because those are the rules. And what it looks like is if you don't have one, that you don't have any rules and anything goes, right? Not that that's really how it is, but that's what it could look like if you don't have an employee handbook. If you have subcontractors, having a well-written subcontract is perfect evidence to prove that they're really a subcontractor. So just because, work orders are all right, or, just directions for that particular job, but you should really have an MSA or also known as a master subcontract agreement, that they only sign once, that you go through the specific terms that apply to every job as far as insurance and all the other things that are required. So that's another thing. If you have subcontractors, you need a well-written subcontract. Insurance, specifically for your business, right? There are companies out there that specifically write policies for companies in the construction industry. Companies that would write a policy for a painting company that would cover overspray, or things that are likely to happen in their industry that wouldn't be covered under a regular GL policy. So taking the time to find the right company for the right insurance company for your company, have a meeting with them, let them know what you do and your biggest issues and things that you're afraid of, and make sure that they're covered. Because a lot of times you think you have insurance and then something happens and you realize, oh yeah, I don't have the right type of insurance. So, and like, if you are a subcontractor who likes to sub work, general GL policies won't cover the work of your subcontractor. So, there are policies you can buy that will. So just some things to keep in consideration there. All right, if your customers are signing your contract, it needs to be something that's in plain English that both of you understand. And so this is more of my residential remodel repair guys, or anybody that's working for a homeowner, either a new build or anything. It's being specific about what's required, and we'll kind of dive into that a little bit more about the general parts of what you should expect to be in there. But the main thing is that if we can manage expectations, we'll be less likely to end up in a dispute later on. And so that's what a contract's supposed to do. If you're signing somebody else's contract, even if you don't want to negotiate its terms, I highly recommend that you figure out what it means. And I think right now the current state of the subcontracts and most contracts that are in the construction industry right now don't do a good job at what they're supposed to do. What they're supposed to do is be like another set, like a plans. There's supposed to be another set of instructions of what you have to do for a change order and all of these other things, but they're written in such a way that nobody can understand what they need to do. And the other part is they shift all the liability to the person signing the contract. So even if you don't want to deal with the shifting of liability, if you can understand the risks that you're agreeing to, you can decide if you want to take that risk or not. And you could suggest maybe some language where you meet in the middle. I'm not saying that there can't be any risk in the contract, because there is. That's what a contract does, is share the risk, but it shouldn't go all the way to the person who's signing the contract. And then 9, collections. I mean, obviously you work hard, you want to get paid. And from my experience, if you have the best time to set up a collection strategy is when you don't have a collection issue. And that way you make sure you never get into a collection issue. And so knowing the steps you have to take before you'll have to take them. And another one that we've done several on this is know how to CYA or cover your ass throughout a project or throughout anything with well-documented files, emails, all of the things. Because once we enter into the world of having a contract, anything you say verbally won't help you. And so just making sure we keep track of everything that's so very important in this industry to prevent you from being in a dispute later on, or if you do, having all the right evidence to prove you didn't do anything wrong. So that's kind of the overall checklist. We're going to dive into a few of these a little deeper. And if you have any other questions about the other ones, we can always schedule something to talk about those more in depth. Okay. How to avoid an employee legal landmine. So the first thing is, what is the difference between an employee and a subcontractor? Okay, so it doesn't matter what you call them, it matters what the law calls them. And the general rule is the more control you have over an employee and what a person, what's called whether it's an employee or subcontractor, the more likely they are to be an employee. So like a true subcontractor has his own equipment, has his own business, and he's one of the, he works for you, but he also works for other people, right? So that's truly a subcontractor, and we want to have a subcontractor agreement with them. But if somebody shows up to only your jobs, using your tools, you are their only one giving them direction, that's more likely an employee. And so knowing the difference, and there's different, factors to be considered based on your business. And so it'd be worth a call to figure it out, because the ramifications of getting it wrong can be large. And that's why it's a huge landmine that people don't even realize is there until they hit it. So, because one of the, like, if you, next slide, thank you. If it's determined that you have an employee, right, you need to withhold taxes and you need to pay them overtime. And the overtime applies even if they're salary, right? Unless it's a higher level person, like, a manager or somebody that's managing people could probably just get away with just have the salary and not have the 40-hour a week requirement. But regardless of, even if they're on salary, or if they need to keep track of their time and prove how many hours they're working in a week, and you can't do daily rates. It's got to be based on hours worked. So I once had a painting client who was super busy, big commercial jobs all the time, and he, got real busy, and they were buying the material, he was just laboring, so he would hire people as, contractors, as subcontractors, and actually would hire them as employees and just paying them salary. And about after a year of this, one of the employees got upset with the way the business was being run and quit. And about 2 weeks thereafter, my client got a demand letter from a law firm that, he was entitled to overtime and he wasn't paid this overtime. Okay, and so the client's like, okay, well, let's just figure out what this is and take care of this. That would be ideal, right? We can just limit the liability here. But what actually happens is that you, as the employer, will be sued in federal court, and the employee's attorney will be able to open your records and see who's worked for you for the last 3 years, and send letters to them and say, hey, you may be entitled to overtime, so you probably want to join this lawsuit if you think that you are. And so this happens over a course of months. We give them the list, they get to send the letter, the people can opt in, and then once we figure out who all these people are and who's going to opt in, then we'll talk about settling. And so it goes way beyond just the one person that, that made the claim of overtime into the whole thing. And in that instance, it ended up costing, $30,000 in overtime and penalties, and then another $20,000 in attorney's fees just to get there. And litigation is nervous enough, but when you're being sued in federal court and they open up your books and records, it's a stressful situation. So the main thing is, let's talk about if you have employees or subcontractors, and if you have employees, let's make sure that we're paying them right. Okay, employee handbooks, like I said, the best defense, especially if there's an accident on the job or if OSHA shows up, the first thing that they're going to ask for is your employee handbook with an updated safety plan. Also, it gives, disputes like for write-ups, what is your write-up policy? What is your termination policy? If that's all written up and people sign off on it beforehand, it's something that can be enforced. If not, they can say the rules are whatever the rules are, and you really don't have any pushback to say, no, that's not the way things were, because we don't have a set of rules, right? A set of rules that everybody signs off on as soon as they start working is the best policy. So employee handbooks. All right, next slide. Avoiding the litigation landmine. All right, so a lot of litigation comes from mismanaged or unmanaged expectations, or not understanding what you agreed to do. So the best way to avoid the litigation landmine is, let's be clear on expectations. And so how do we do that? We need to understand the contracts that we sign, and our customers and us need to understand the contracts that they sign for us. And so the best way to do that is let's make everything in plain English so everybody can understand it, right? Which is the next slide. Understanding, we'll go over the parts that you should put in your contract if someone's signing your contract. If you're signing someone else's contract, let's understand what it says, what the risks are, is there a paid when paid clause, all of those things, so you can understand the risk that you're taking. So the main thing to remember in this is that if you're signing, next slide, please, Chelsea. If you're signing somebody else's contract, there's no set of rules that'll protect you. Whatever you sign will be used against you. And so not understanding what's in there is crucial. And, you know, I'm kind of jaded on this because I never see a good project, right? And so all I see is the messed up ones. And I don't think that these documents are ever intended to be used the way that they can be used in litigation. But once you've given them the weapons, once you sign a contract that you don't know what the terms are, and they're all very one-sided, and then at their option, it can be used against you. And so just knowing what those are and the ability to try to negotiate, you know, especially now, we have more ability to negotiate because it's harder to get workers. There's a lot of work out there. Everybody wants to get work done, and that's fine. Let's just take the time to go through these things and understand what we're really signing and what the risks are. Because if we sign something that we don't understand, and you know, it has a pay when paid clause, and for some reason you don't get paid for the entire project, could you afford to float the entire contract amount for the whole project? Because with a pay when paid clause, that could really happen. So just some things to take in consideration when signing somebody else's contract. All right, so some basic, you're going to have someone sign your contract. Here are some of the basic things that you'd want in that contract. Who is hiring you legally? Is it, you know, the correct name of the entity? Is it an individual? If it's a property owned by husband and wife, make sure that both the husband and wife are on the contract and that both of them sign the contract. That could be, you know, important later on. Include the address of where the work is actually done, the address, the project name, so we can find it later on. If there's a collection issue, we need to file a lien. Scope of work. This is a huge one. If you're signing, you know, if your customer's signing your contract, your estimate can be used. You have to incorporate it in there. Anything that changes, just make sure you know, based on your experience, also include what might not be included, right? So you guys are, you know, expert at what you do, and you know, sometimes people might think things are included that are not. So just let's be upfront about it, and there's less likely to be a dispute. And you guys, okay, so you can take these 10 things and just write your own contract. Super easy. Any kind of contract is better than no contract at all. And especially if you think you're doing someone a favor, or, you know, a friend asked me to do this, those are definitely the projects you need contracts on. Those, like, not there's a lot of those that end up in my office for litigation. So even if you just think you're doing somebody, even if you're not going to charge, you're doing it for free, let's have an agreement of what's included, so we're upfront and it's all in there. So the fourth thing on here, schedule. Be realistic about when you can complete things and when you can't, and allow in there, you know, extra time that you can get extra time if you can't get materials or if you can't get workers up front, so that, you know, whoever's hiring you know that could be a potential issue, which kind of goes into the next one, which is the material escalation clause. So guys, with the crazy prices of materials, whether someone's signing your contract or if you're signing somebody else's contract, if you don't have a clause in there that allows you to recover the increased cost of materials, you won't be able to, right? So I have some great language on my website you can add to your contracts that just says, you know, if material prices increase more than 2%, I'm entitled to get that much back. But just know that if you don't have that in a contract you sign with somebody else, like a subcontract agreement, you can't get that increased cost back. You can try to submit a change order for it, but if there's no legal obligation to do it, it's very unlikely that it's going to get signed. Okay, so the material escalation clause should be in your contract. Number 6, how to handle change orders or changes in work, especially on the residential side. When a homeowner hires you, they have a certain set of expectations that you are an expert, you know exactly what you're doing. And so if there's changes, sometimes it can be, you know, unexpected and disruptive. So if we're just upfront in our contracts and saying, yes, I'm an expert at what I do, but there still may be changes, and if there are, here's how we're going to handle them. You know, we can put in there how it's going to resolve itself. It's cost plus a certain percentage, or I'll provide you with a couple different options and you can pick. It just all depends on how your business operates. So changes in work and payment schedule. very obvious, obvious to us that we need to get paid for the work, but sometimes the customers we work for don't know when or how we expect payment. So let's make sure that's clear in the contract. Are you going to submit an invoice? Is it milestones? Is it part down and part on completion? Whatever it is, let's just make sure it's spelled out. Also include a default and termination provision. A default is basically you're not following some term of the contract, but I'm going to give you notice before I terminate the agreement and a chance to cure that default. So when you don't cure the default, then you can be terminated. And sometimes you like to leave yourself an out to terminate for any reason if you don't necessarily if the relationship is not getting along well. So that's kind of contract specific and based on what your business is really looking for, so we can have a discussion about that. Warranty is another huge thing. What is your warranty? What does it cover? Is maintenance, and a clear statement that there's some homeowner maintenance that is not, or customer maintenance that is not included in the warranty. Another huge thing to put in the warranty clause is that you're not obligated to do warranty calls until you've been paid in full on all work. And this goes on the commercial side as well. That I'm not going to honor warranty calls until we've been paid in full with everything but retainage, everything including retainage. And then 10, how will disputes be settled? Are we going to arbitration, litigation? Who's going to get their attorney's fees? Having that all spelled out in advance is helpful. That way everybody knows where we're going. A good idea to always have mediation before we jump off into litigation to try to settle things. In Texas, if you're a residential contractor, Texas is kind of built in their very own mediation process before you can sue a builder. And it's called RECLA, and it's the homeowner's got to send you a letter listing everything wrong. Then you get a chance to inspect and respond with a reasonable offer. And if you do all that and have a really reasonable offer, you can limit your liability later on. So that's a great tool if you're a residential contractor. Okay, next slide, Chelsea. Absolutely must collect your money. Next slide. Oxygen for your business. Tom Reber's book, Winning the Contractor Fight, which is a great book for residential contractors. If you haven't picked it up yet, I highly recommend. You can get it on Amazon. Talks about cash flow being oxygen for your business. Absolutely 100% is. Your business has bills to pay, operational costs, all of those things need to be paid and can only be paid if you're paid. So creating a consistent collection strategy before there's a collection issue is huge, because lien rights are different in every state. Texas has some of the most confusing ones. More about that, you can check out my book, Quit Getting Stiff. It's got them all broken down. So next slide. Because this is common that I've seen in the construction industry is a business, and I had a concrete, it was a curb company actually, did concrete curbs, that was so busy, was always working, but they had no money. They had no cash. They couldn't operate. They always had a hard time making payroll. And so when they met us, we looked at their open invoice report, and they had over $600,000 worth of money that was over 90 days old. And so they were basically financing everybody else's project. And in Texas, you're out of lien rights too. And so we worked real hard and were able to collect most of that money. I think they ended up writing off 100 grand, which is still a huge amount. But from that point forward, we got them on a consistent collection strategy. And so once you can do that, your write-off goes way down in percentage to like less than 1 or 2%, to make sure you're collecting the amount that you're owed. So, using those lien rights and just having collection strategy, whether it's not even, making phone calls or turning it over to the law firm to make phone calls or send letters. It just needs to, whatever it is, it needs to be decided on the front end before you start working and then waiting to get paid, because that's what the construction industry is. You work and wait to get paid, which is a form of credit. And so a lien is a way to secure that credit. So next slide. So all 50 states have lien rights, and knowing what they required for your state is hugely essential, because you can secure the amount that you're owed by the property by filing a lien, but it has to be done properly. It has to be done timely. And so incorporating the lien process into your collection strategy makes it kind of, bulletproof. You will, as long as everything's gone, the work was done good and all the things like that, you have a lien on the property and you'll be likely to get paid. And one thing that I can tell you, if you have a consistent collection strategy, most of the time you don't even have to file a lien. And just from my experience, once you become the squeaky wheel, you do get paid, right? And 90% of the people that I start collections for, I don't ever have to file liens because we make phone calls. We're doing everything we can to collect that money before it gets to that part, because nobody wants a lien filed. And in every state, notice is required before you file a lien. So use that notice, right? The sooner you send notice, the better. There is no, you can't send notice too early. You can only send it too late. So always sending notice as soon as you know that there's an issue, because the whole thing is to give the people who are in control of the funds a chance to pay you before they have to pay twice. So that's kind of my short down and dirty on liens and collections and all of the things, legal landmines. Well, not all of the things, but a majority of the ones that I would counsel any new business on. And so now I'm here to take any questions, particular related to this or not. Anything you kind of have questions on, I can answer. Well, I'll try. Anyways.
Alrighty, if anyone's got any questions, feel free to either unmute yourself and ask Karalynn or send them in the chat. And if you can't think of anything just now, no worries. We'll be sending you her contact information after this, as well as the presentation for you guys to reference for your notes. Let's see, we've got one here from Andrew Sefton. Previously sought bid checklist. Is it something on the to-do list?
I have a whole chapter on bids and like a bid form that you're looking for at Subcontractor Institute. Is for free. Kind of what a bid is, although any bid that's submitted currently, which should probably have a provision in there about the escalation of materials and shortage of labor, which I have a great blog article on that too at the website. I'm not sure if I'm answering your question, so I'm not. Feel free to unmute yourself and ask me directly.
Andrew said a checklist that an estimator would follow when submitting a bid, stuff to look for.
I'm trying to think. I've not created one of those. And I guess it's going to be trade specific too. The main thing is that once you submit your bid, when you get a subcontract back, that's when we would look to make sure that the two are the same, right? So the bid that you submit is not necessarily the scope that's on the contract. So if you submit a bid, and depending on who you're submitting the bid to, if we're signing off on paperwork that's in addition to your bid, some things to watch out for are they excluding? So some things to watch out for, are they excluding your capability to recover increased material cost? What about, this is stuff that I would put in my bid that could be excluded by something you've signed. How long is your bid good for? Another thing to look out for. What are if they have any pre-terms of the subcontract agreement? What are those to look out for? Is there going to be a paid when paid clause? Is there a bond requirement? All of those things that you need to look out for.
Karalynn, Brad Bunch with the Jolly Group.
Yes, sir.
I have a question regarding retainage.
Yes, sir. Go ahead.
We had our company meeting this morning, and the accounting department was complaining about it takes forever to get paid on retainage. And so I had an idea up front in perhaps negotiating the subcontract up front, not necessarily the percent of retainage, but the time to pay the retainage. You got any experience in that?
I mean, you can absolutely try. The problem is there's two problems with retainage, right? The pay when paid clause. Is the owner really paid the GC for the work? The second part is there's no leverage left, right? They don't need you to show up at the job anymore. And so, yeah, they got paid and they'll get it to you sometime. So in my experience, the best way to do it is to build into your contract amount the cost of filing a lien for retainage. That way, when you're done or towards the end of the project, you file the lien just for retainage. And that way the owner will either pay you out of the GC's funds or you will be the first one to get paid. Because here's the problem. If we don't file a lien for retainage, you can't file a lien. And then you're basically just whenever they feel like paying you, they can. And then what sometimes happens, I'm not saying all the time, is that they'll wait on purpose and then be like, oh, hey, you know, there's some bad things happen on this job. Will you take a 30% cut on the retainage that you're owed? Or would you waive it at all, right? So just that from my experience, I don't know how successful you will be negotiating it in the contract. Because here's the thing, the definition of retainage does not apply to subcontractors, right? Retainage is only between an owner and general. Now it flows down to subs, which is probably why that it wouldn't be successful. But if you plan on filing a lien for retainage every time, you'll get paid. You'll get paid first. That's what I've seen be successful.
Thank you.
Got another question in the chat here from Jorge. How successful are subs in changing the contract to include the changes you mentioned? Do you have the subcontracting form available?
Yeah, I mean, so what I have at Subcontractor Institute, I have all of the things to look out for, or you can hire us for a flat fee to look at your contract and kind of tell you where the risks are, and then you can decide what to negotiate on and what not. And so it really depends on the general contractor and whether or not you're going to be successful. The thing that I can tell you is that most PMs that you're dealing with don't even realize the risks that are in those things. And so sometimes if you can explain it to them with a way like, hey, I can't afford to take this whole risk of non-payment. Let's split the difference. Let's find something in the middle. So, you know, I've seen it be pretty successful, especially it's getting more and more successful because good contractors are harder and harder to find. And so if you have a good relationship with a GC and they enjoy working with you, that is worth a lot, right? They will jump through hoops to make sure that they get to work with you because it just saves them so much time and headache down the road. So the more you can build that relationship, the more likely you'll be able to change things. So yeah, it all kind of depends. And here's the thing is that it's never we're going to just cross it out and not deal with it, where it's like, okay, here's our problem with it, let's meet somewhere in the middle. Because just as much as they want to push it all down to you, you can't say, no, I'm not going to do any of it. Let's meet somewhere in the middle. So it can be successful. It just all depends. And here's the thing is that I can give you the keys and the wording to do it on your own, so it doesn't look like it's coming from an attorney, which can also be, you know, it's one thing to try to negotiate on your own, but everybody's already on edge if you have an attorney before you sign the contract.
All righty. Do we have any other questions for Karalynn this morning?
Well, thank you guys for coming. Have a wonderful afternoon and a wonderful weekend.
Thanks for joining us, everyone. Have a good one.
Next month, guys.